far as the first matter is concerned, my lord, it is already listed on 30th, my lord, 30th October this month. My lord, let it be appear at the top so that I can avail the flight that day. Subject to correction, my lord, there's one more matter which I have filed and it is placed for scrutiny. I have not received the number till now. Within the course of the day, I shall be giving the number to your lordship's staff, my lord, so that both the matter can be taken up serially, my lord.
No, but have you given notice to the other side?
My lord, yes. So far as this 30th matter is concerned, it is filing.
The fresh matter you are filing.
Yes, it is in the already filed, my lord.
No, are you mentioning today upon notice?
On the other side, how could I mention, my lord, unless I get the number, my lord? So far the first matter is concerned, I at the instruction, my lord, the person who is appearing for the respondent in the first matter, he is also appearing in the second matter. In both the
the same set of respondents are there.
More or less, my lord. Union of India, my lord.
Anyone is appearing for the Union of India?
Normally appears, my lord, for Union of India.
Yes, madam, you appear for the Union of India. So 30th there is one matter fixed. What your
this matter. Okay. Along with that, I am filing one matter today. Both the matter will appear serially, my lord.
But you have to serve them.
Already,
are they arising out of the same?
No, my lord. Different matter, my lord.
Let it be listed. Let it be listed. Listed. Subject to scrutiny. If there is a defect, that defects. Well, who is your advocate on record? He has to remove the defects if there will be any.
He is already before the department, my lord.
Yes, subject to the scrutiny. If it is in order, then
this is the scrutiny matter.
And you have to serve the Union of India.
But in course of day shall file. And this is the matter which is already appearing.
Because 30th, the other matter is
on 30th. I've been told, my lord, so far as they have a different kind of mentioning memo here, my lord.
We need to mention memo, sir.
Mentioning memo. Yes, the mentioning memo has to be there. The procedure has to be there.
So
you file it in any event, 30th, I think all matters will be listed.
But serially, my
fresh. That will be mentioned in the morning, then we'll take it up. If it is otherwise in order, it will appear. No problem. All matters are appearing.
Item number 1.
May I be permitted to submit the memo in course of the day today?
Item number 1.
Orders.
Made, please.
Madam President, the Lordship will leave granted to me. We have filed the service affidavit yesterday showing the serving our service to respondent number 14 to 17 has been effected, my lord. Madam, can you see para 5?
Civil service report from the department. Huh?
My lord, para 5 of my affidavit, we have a spell out in detail.
Delivery office. It only mentions about the delivery office.
Yes, the postal department has provided that it has been delivered.
That means it has reached the maybe the post office there.
Yes.
Block post office maybe.
Post office report is, my lord, page number 11.
And then where's a proof of service? Whether these persons have received the notice, that is an important thing. It only shows. Normally they send that is delivered to such and such person.
Yes.
And if the ID card is there, then the ID card should come back.
But sometimes the ID card did not return. And because of that, we used to obtain report from the postal department. And they used to give a report. On that basis, we used to file a service evidence.
There is I don't know, but in Calcutta we have this track report, track consignment report, wherefrom you can find out that whether this person addressee has received the notice or not.
Right. My lord is correct. Registered AD should return, in fact, from the postal department. My lord, in my page 11, normally if it is not delivered, the postal department reflect in the report.
It's not indicated in the report.
My lord, it is
It only
indicated they
says
have
it
delivered.
reached to the block post office or something like that. These are all maybe the.
We do have a
Found somewhere. Please call someone from the department. Who has filed this report? Where is the report of the department? Where is the report of the department? Where is the report of the department? Department was to file a revised. Respondents.
They are not contesting respondents. They are the local headmen, 4 village headmen.
Sorry?
They are not the contesting parties.
Hetman.
It's a land negotiation matters. My lord.
Oh. No, they have not filed any affidavits.
They did not. They are newly implemented my lord, in the second round of litigation.
No, they have not contested. You can dismiss. The appellants before the Supreme Court. This
No, we were the appellant.
But how this 14 to 17?
My
They were in
lord,
the
What happened, my lord, after single bench decided the entire issue and directed the government to conduct survey, and if the land is underwater,
Contesting respondents.
they are not the contesting respondents.
So they are the contesting respondent with respect, my lord, because our case is that land is owned by the clan and they have donated the land. This very order was challenged by the appellant. This interim order of impleadment was challenged by the appellant before the Honorable Supreme Court, my lord. Notice was issued after hearing that their SLP has been dismissed. Our case is that they are real affected party, my lord. So, and they are the head of the clan and who have donated the land, my lord. So that's my case, my lord. Lordship. So service on them is necessary in my humble submission, my lord.
No, before the learned single judge,
Yes, my lord.
they were parties.
They are not the parties, my lord.
They were not parties.
my lord. So learning single bench decided the writ petition, directing the government to conduct a survey, and if the land is under the water, direct the government to acquire the land. We prefer the instant writ appeal. During this instance of writ appeal, this will be to direct the government to conduct the survey. They conducted the survey and found that the land is under the water. So in view of that, subsequently, my lord, before this matter was decided, finally, the government came up with the implementing application, seeking for implement of those 4 local amendments, saying that there was an agreement and one of the landowner has donated the land to them, And this four headmen has given the same land to the government. Agree with that, we filed a SLP. And this the Honorable Supreme Court also issued notice to them. They received the notice, they did not contest before the Supreme Court also. And subsequently, my SLP was declined to interfere with. So this dismissed my SLP and requested this Honorable to proceed the matter expeditiously. So thereafter, my Lord, with pursuance to Lordship order, we have taken steps. Service has been effected to those four local headmen. This is the position. So they are not the contesting party till to date.
So how you are agreed by these directions? Three directions are there in the order.
My Lord, in fact, it has been complied with. Earlier, my Lord, why did we filed an appeal, limited the prayer that the government was the same department which was contesting in the single bench, saying that the land is inundated. And London single bench directed the same authority to conduct the survey. So we found some agree. We saw the survey to be conducted by the collector or the water commission. That was the limited prayer.
No, this already, you see, this paragraph 15
Yes.
is a very innocuous direction. It's for the benefit of all. So how you are agreed by this direction?
And therefore, they have complied with the order. Government has
how you
complied
are
with the
agreeing?
order. Survey has been conducted. Survey report has been submitted to this Honorable Court. So I would pray, madam, since they are yet to appear, may they be taken up madam, after a week or so. Who knows, they may appear.
You see that you prefer an SLP against order.
Yes.
Your appeal is pending, correct?
But
The Supreme Court did not comply with this order.
madam,
The Honorable Supreme Court did not comply with this order and only said that we request the High Court to take up the matter expeditiously and decide the same as early as possible. Now, if these directions have already in the meantime complied with, so please tell us how these directions really affect your right.
my lord, we went to Supreme Court. My lord, being agreed with the implement of those four headments.
Implement of these foreigners.
Four headments. Saying that at the final end of the litigation, but final end of the litigation, government came up with the implementing application. And this Honorable Court implemented them. So we found agreed with that. We went to Supreme Court for that purpose.
Where in that order, impugned order, there is an observation that they are to be implemented as parties?
Madam,
My lord, the order which was assailed in the Supreme Court is order dated 29 February 2024, my lord.
Not the impugned order.
No, my lord. My lord, state has made an application for implement of the Dorbashno, my lord, who has
During the pendency of the writ petition.
my lord, yes, during the pendency of this appeal, my lord. Because after examining, my lord, there is an agreement, my lord.
The writ petition that was disposed of,
My lord.
in the writ petition, are they parties?
They will not make a party, my
They
lord.
were not
They were not
parties.
parties. They were
They will not make a party.
They were not. No, so they made an application for implement in the appellate stage,
yes, before this,
Yes, my lord.
before the division bench.
and the division bench allowed that prayer.
Allowed that prayer. So being agreed with it, we went to Supreme Court.
No, so
It was allowed, my lord.
no, these persons were added because of the state's contention.
My lord.
That these persons have donated the lands.
My lord.
Yes, donated.
Yes, my lord.
My
Gifted to
lord.
the government.
Correct, my lord.
But how that is relevant for the purpose of deciding the impugned order?
Exactly, sir.
Because,
that-
my lord, the landowners are seeking compensation, my lord. They are seeking compensation, and their case is that their land is getting submerged in rainy season. That's the case of the landowners are the purported alleged landowners are, my lord. Our case is that the land has been donated by virtue of the deed signed by the clan and other members, and clan headman has signed those deeds, and therefore the clan is, if at all, a compensation will have to go. It will have to go to the clan because clan is the headman of the clan is the affected party, and they will not
But why at the stage of hearing of the writ petition you have not implemented them?
because the writ was
That's
filed by my learned friend, my lord. My writ was filed by my learned friend, and my friend has not implemented them despite in the gift deed the clan headman signatures are there. They were not implemented.
But have you disclosed that in your affidavit before the learned single judge?
My lord, yes, my lord, we have taken that stand, and thereafter your lordship has passed a detailed order implementing them as one of the respondent 14 to 17. That very order
No,
was challenged.
what you are saying that before the learned single judge, did you take
Yes,
the
my
point that the writ petition is not maintainable because of non-joinder of necessary parties? Have you taken that
That,
point?
my lord, I have Milord, that aspect I have to check again, but because the what has happened, Milord, that aspect I will revert, Milord, on next date of hearing after examining the pleadings, Milord. But what has happened in the meantime, when matter came before Your Lordship has been pleased to pass a detailed order impleading them, Milord. And that very impleadment order was challenged by my friend before the Honorable Supreme Court. And Honorable Supreme Court upheld the order of impleadment of respond number 14 to 17, Milord. To that extent, in my humble submission, the impleadment aspect has attained finality, Milord, because that very order was challenged and by before the Honorable Supreme Court, Milord. And if Your Lordship will see the orders by which they have been the deed of transfer by which they have been impleaded, Milord, that will also show that they were necessary party and therefore the contention of the state before the Honorable Supreme Court that they are necessary party in SLP has been dismissed. The SLP of writ petitioner before the Honorable Supreme Court has been dismissed, Milord. So, in humble submission, my lord, it is now not open to the appellant to argue that they are not necessary party now, my lord. Once the order of the Honorable Supreme Court to that extent has attained finality, my lord.
The first writ petition we filed in 2016, state filed affidavit, they never take the plea of non-joinder of the parties. Writ petition was disposed of, my lord, directing the Chief Secretary to take a final decision. Chief Secretary has taken a final decision to acquire the land. Thereafter, they never pay the compensation. So 2019, my lord, they filed the second writ petition. In the second writ petition, my lord, also did not take the plea that those four headmen are not implemented as a party. They never take that plea. So the second writ petition matter proceeded for final hearing. The single bench decided the matter in my favor partially, my lord. With a limited prayer, my lord, for conducting inquiry, we filed the writ appeal. And this learned bench has directed the government to conduct the survey, complete the survey. They conducted the survey, completed the survey, and given a report before the Supreme Court showing that the land is under water from 2011. So pursuant to the single bench direction, they have to acquire the submerged land. Before my lord decide this issue, they filed the impleading application.
suppose. Mr. Advocate General, this headman,
Yes, ma'am. Yes,
how
ma'am.
he can improve the situation? Suppose it is subject to, for our understanding, subject
Yes,
that
ma'am.
the land belongs to me.
Yes, ma'am.
That land has been either being acquired or whatever the reason. So the compensation must come to me. Now,
Yes, ma'am.
can the headman decide that, well, this land may belong to you, but is being donated to you? Donation can be by a person, or a gift can be by a person who is the owner of the land.
Yes, ma'am.
It cannot be by the headman.
Yes, Milord. No,
So how
yes, Milord. I follow what is falling from your lordship. Is this, Milord? There are two types of land structure in Meghalaya, Milord. One is called re-ride and re-kinti. Re-kinti is the individual right, and re-ride is a personal. Re-ride is a community land. The case of the state is, my lord, that the individual has donated the land, entire land, to the clan headman. It went to the community land, and community entered into an agreement with the state saying that I am giving you a piece of land for setting up water supply project, and cost of water supply project then was, my lord, when it was set up, it was only 8 crore rupees. Now for 8 crore rupees, about 200,000 people are getting the drinking water supply. It so happened, my lord, in 2000, 2000 people. Now, if the land is to be acquired and the compensation is to be paid to the individual owners, our case said that they are not the owners, my lord. The community has donated the land. Community was the owning the land in terms of the land system prevailing in Meghalaya. Now, if their plea is accepted, my lord, the cost of compensation will go to 80 crore rupees, and the entire project will become unviable for the state, my lord, because even I go for greenfield project, my lord, I will be able to provide water supplies to 2,000 or odd villages by in less than half of the cost, less than half of the cost of the entire amount, my lord. So therefore, on that count, my lord, because time to time interim orders have been passed by this honorable court, examining this aspect first, whether the land has been donated rightly by the clan, or clan is the owner, or the individuals are the owner. 2-3 surveys have been conducted. My lord, first survey which was conducted in 2011, it was noticed that during rainy season submergence takes place nearby dam area. So near that was because sometimes because of heavy rain also during rainy season, my lord, there is a submergence. Whether it is because of the small check dam it is taking place, or it is a natural phenomena, that report has also not been there. That is one aspect of the matter. Second, my lord, who is entitled to compensation at all. Third issue is, my lord, if the cost of the project will go beyond the viability, my lord, then state government may scrap the entire project and return the land to the community. These are the three issues which are pending in the
see,
writ.
we are only presently concerned with the appeal
Yes, ma'am.
preferred by the writ petitioners.
Yes, madam.
So 3 or 4 directions have been given by the learned single judge.
Yes, madam.
So what the issue I have raised in the appeal is, who is ultimately going to get the compensation?
Yes, madam.
But that issue
And
is not.
And a
But
fresh survey, the learned single judge has also directed a fresh survey, my lord.
yes. So if we do not interfere with the order, who ultimately will get the compensation or not, that has not been decided in the writ petition.
Yes, my lord.
So as and when that issue comes up for consideration,
Yes, my lord.
that may be
Yes, my
considered.
lord.
But we are now restricting ourselves that whether the impugned order is sustainable in law or not.
Yes, my lord.
Your implement, if we have understood it correctly, your implement is only limited to the issue of showing that ultimately who is going to be receiving the compensation.
And the second aspect is also, my lord, that the land has been donated free of cost by the clan, my lord. So therefore, the payment of compensation will also not arise. Both the aspects, in my humble submission, require consideration, my lord.
But then that
And
that
we will
that
file
issue,
our written argument,
no,
my lord.
no, no.
We
But that issue
will,
have not raised before the. You are raising it before the. See, it is
if
not
you
your
lordship
appeal.
will kindly see
It
my
is not.
submissions have been noted.
No, no. It is not your
That,
appeal.
yes, my lord. Yes.
So Roman one of the deduction, Roman one of the
Yes, my lord.
deduction, you are not objecting to it.
Well,
Roman
Yes,
one
my
of the
lord. This,
deduction,
yes.
yes,
And state is not
paragraph
finding it.
15, Roman 1,
Yes.
you are not disputing
yes, my lord.
this.
Yes, yes.
If your lordship will kindly see the impugned order, page 358, my lord. 358.
No, we are
Roman
going,
2.
the operative portion is paragraph 15.
Yes.
So paragraph 15.1 is a fresh survey. Identify and establish as to whether lands of the petitioners remain submerged. Now, whether you see, whether he gets or the community gets,
Yes, my lord.
one is essential.
Yes, my lord.
Whether he gets or the community gets the compensation, Roman 1 is essential. Second is, if the same after survey and examination is found to be true as alleged by petitioners, the respondent shall initiate the process for acquisition of the said portions of land and have remained submerged till date.
Yes.
Now, what you are arguing now is that even if it is being ascertained and the acquisition is there, but this was given to you free of cost.
Yes, my lord.
So this issue you have never raised in the writ petition.
Exactly.
In fact, it is there, but it is in my
No, no.
submissions have been noted, my lord. But we are not in appeal. Your lordship is right. We are not in
Yes,
appeal.
you have not filed any appeal.
They did not find
Yes,
it.
my lord.
Next, if it is found otherwise that after only one instance, portions of land have been submerged, which has not occurred since, after due identification of the owners, the plots were affected in the collector shall, in the amount only deposited by the PHE since apportion the said amount as compensation plan bonus. Now, you have already deposited this amount.
Yes.
There was a survey, my lord, regarding some. There was a survey. This is also of 2011, my lord. So there was no clarity.
Once you have deposited the amount by the PHE, that means that is towards the compensation.
Exactly.
No, my lord, what has happened, my lord, facts are slightly convoluted in the sense, my lord, that if the compensation has to be deposited, it has to be deposited with the adjudicating authority, that is district and session judge, my lord. That money
No,
was not.
provided there is a reference under section 18.
Yes, there is no reference, my lord.
So there is no,
There is
since
no.
there is no reference,
Yes, my
so in
lord.
any event, the collector has to pay this amount to the landowners.
In case it is found, my lord, that they are
If no,
affected,
if no, if no, if no section 18 proceeding is initiated. If
Yes,
no
my
Section
lord.
18 proceeding is initiated, then this amount, and only after a Section 18 is there, then they deposit this amount in court.
Yes, my lord.
Or the owners may take this amount subject to their preserving their right for enhanced compensation.
Yes, my lord.
Now, collector has already deposited this amount. Rather,
The
collector is
state,
retaining this amount, not depositing. Collector is retaining this amount.
yes,
So,
this amount
Roman,
was retained.
yes,
Yes, my lord.
this
This amount
collector,
was transferred from one department to the other, PHE to the district administration, my lord. This is the case, my
see,
lord.
the collector is the authority who is to assess.
No, so that process has not taken place, my lord. That process has also not taken place, my lord.
No, the collector has not adjudicated.
No, there is no adjudication, my lord. That is a assessment by PHE department on their own, my lord. If I can place all
So no,
those
so
facts.
PHE is the acquiring authority. Rather
Because,
the requiring body, the requiring body.
yes,
State
requiring, yes,
acquires
my
it
lord,
for PHE.
requiring,
So state acquires
yes,
it for
requiring.
the PHE. So PHE is the requiring body. So the requiring body has deposited this amount. According to them, this would be the amount of compensation, according to their own assessment.
No, what has happened, my lord, if I put the record straight, the dam was built by 2010 and everything was done. Then there was a demand for acquisition of land. PHE went on their own without examining whether the land has been given free of cost or what. They said that we need to pay 6 crore rupees to the affected parties, etc. The government transferred it. Thereafter, the writ was came to be filed in 2016 after about 8-10 years, saying that then this honorable court directed the chief secretary to examine the entire matter afresh. Chief secretary took a decision whether the submergence is regular phenomena, is a partial phenomena, whether the 6 crores should be given or not. It was taken a view that in the report of the chief secretary to this honorable court, my lord, and they are not entitled to any compensation. That was the stand taken by the chief secretary. That came to be assailed by my friend by way of fresh writ petition, from which this petition has emerged, my lord. So therefore, all these aspects are, in my humble submission, require some examination by this appellate court whether they
No,
are.
you see that there is no cross appeal. So we proceed
Yes,
on the
there is no
basis of the
cost.
directions. So
Yes, my lord.
directions are in, there are three distinct directions.
Yes, my lord.
First direction is you make a survey.
Yes.
So second is that if the survey is there, then on the examination of the report by the surveyor, whatever is there, if this land has already been acquired, then, or rather required, then the process of acquisition of the said portion has to be initiated, the portion which has been
Yes.
submerged.
Yes, my lord.
By reason of the construction of the dam, if it is an adjacent to the dam and by reason of the construction that adjacent area is submerged, then that portion has to be acquired.
Yes.
Because whatever I could have whatever I have understood is this, that during the construction of the dam, possibly some areas have been submerged.
Yes, my
So
lord.
it's not restricted to the area which is over which the dam is now presently located, but the surrounding
Yes, my lord.
areas which got submerged because of the construction of the dam. So to the
Yes, my
extent
lord.
of those areas in excess of the land over which the dam is constructed, so you have to quantify compensation for that additional area, which may
Yes,
not
my
be
lord.
the original acquisition notice, could be.
Yes, my lord.
So once it is established that that portion is submerged, then for addition of this, it appears that the PHE themselves, on their own volition or on the basis of whatever record they have
Correct.
assessed the compensation for that additional areas, if they were
Yes, my lord.
submerged, the submerged areas, as 6
Yes, my lord.
crores.
Yes, my lord.
So in that event, if it is found that the area over which the petitioners are claiming ownership have been submerged during the construction of the dam, and thereby they lost their right to enjoy the said property, and which according to the PHE would be about 6 crores and above, so that amount would be paid to the rightful claimants.
Yes,
These
my
are
lord.
the directions. Now, a
Yes, my lord.
survey has taken place. Roman 115.1 has been
No, my lord, that has not taken place after the order of learned single judge, my lord. Matter was pending because my friend has filed the appeal, my lord.
So 15.1 has not taken place.
Yes, my lord.
It has been complied with, my lord. That order is reflected by order 16 August 2023, passed by this honorable court.
This 15.1 has been
It is
complied with.
complied with survey report submitted before this honorable court, and on 16
Yes,
August
yes, Mr. Advocate
2020,
General.
2023.
He's
Okay,
saying
my
that
lord, I will have to check the record, my lord, that aspect because, my lord,
It
your
is
lordship
already-
may have it on 4th, my lord. I will be physically present, my lord. I will check the records and I will place all materials, my lord.
now in the application for implement, you have disclosed the what you call gift or donation of the
Yes, my lord.
and
Yes, my lord. That is
by
part of the
the
writ petition.
by the community,
Community, yes, my lord.
by headman of the
Yes,
community
my
to you, free of cost.
lord. Yes, my lord. That document, if your lordship will find, it is there in the writ appeal also at page.
Page.
My lord, I would not show the notifications, how the government would receive gifted from the citizens. There is a notification I'll place it.
No, where is that agreement?
Yes, my lord. That agreement, my friend can point out
My
the
lord,
precise
page
page.
number
Is it at page 316?
Page 200.
228, my lord. Page 228.
228. Now this was not before the learned single judge.
My lord,
No, this was also before the
They have
learned single
annexed,
judgment.
my lord.
they have annexed this agreement, but knowing that, my lord, this agreement is that they never take the plea up and non-implement. Number two, this was never argued before single bench in both the two writ petitions.
I'm saying this 228.
Yes.
220 is the agreement.
My lord.
So you have disclosed in your affidavit in
My lord,
opposition.
this is part of our affidavit in opposition, my
So
lord.
if it is there part of your opposition, then this was not accepted by the learned single judge.
They never argued also.
Then they
No,
did not. This was not accepted.
Yes.
No, learned single judge, my lord, if your lordship will see, learned single judge says that if so far as survey and who is the owner, my lord, if your lordship will come back to the direction part, my lord. First, your lordship kindly see the agreement deed at 228, my lord.
See, Roman 1
Yes, my lord.
directs two things. One is identification of the land, correct?
Yes, my lord.
And then establishment as to whether the lands of the petitioner remain submerged.
Yes, my lord. So if the land of the
Now,
clan
now,
is there,
if you, now suppose one, if you go by maybe your admission or the admission of the PHE, that this land was submerged. Now, whether this land, see, what you are arguing is who is going to receive the compensation, or it will be acquired without any compensation. That's a different issue.
yes, my lord.
So if they were who can donate, provided I am the owner, I can only donate or gift. And then only it
Yes,
get
ma'am.
then it gets subsumed in the community in the community itself. So it becomes merged with the rights of the community.
Yes, my lord.
So when this at the point of time when this land was got submerged or their right to claim compensation arises, whether this land have already been acquired by you on the basis of the agreement of 2007 or not.
Yes, my
Now,
lord.
now this seems to have not been whatever you may have argued, but paragraph 15(1) says identify and establish as to whether lands of the petitioner is being submerged.
Yes, my lord.
And if the same after survey exam is found to be true, the respondent should initiate the process of acquisition.
Yes, my lord.
Because there is no formal acquisition.
Yes, my lord.
But in the meantime, what had happened, PHE had already assessed a compensation and
Yes,
deposited
madam.
to the collector. So
Yes,
it
my
made the task of the collector easy.
Yes, my lord. The only issue is, my lord, that now their case. What they are saying that now that
But
process
why you are
has to.
agreed by this order? Why you preferred an appeal?
But regarding the survey, now the survey has been complied with, madam. So only they have to comply with the single bench direction to acquire the land.
Why you have preferred an appeal?
Madam, with regard to survey,
It's a harakiri for you.
madam, in fact, the PHE itself was a contesting.
It's a harakiri for you. Why you have preferred an appeal?
But that aspect, my lord, it is complied with. Now,
You have won, and you have now you want to enter into uh, this entire uh, web of controversies.
the, the intention of the government seeking for implement is to neutralize and make
Why
it
you have
a
preferred
civil
an appeal in
response.
the first place?
With regard to survey only, man, that is limited aspect only. In my memo of the appeal, the prayer is very clear. That during dependency, the Learned Division Bench of this room court directed the government to conduct survey as per the single bench direction. And the conducted survey report was submitted on 16 August 2023. My lord, kindly see the order.
So what is your
So they have
argument?
complied with. Now only my prayer would be they have to comply with my lord, the later part of the direction
Yeah,
given by single bench.
that they are required to comply with the later part of the order. It
Yes.
cannot be a subject matter of appeal.
Yes,
Appeal means you are agreed by an order.
Yes.
Implementation is not the subject matter, cannot be a subject matter in the appeal.
But-
If they are not doing so, you
They-
move the read code or whatever is
But
there.
madam, they did not file the appeal also, madam. So limited issue here would be, my lord, they have to comply with the single bench direction. If they don't comply, madam, I'll file the contempt. Those procedures are there.
Now, then we can only simply dispose of the appeal by recording that in view of the fact that 15.1 has been complied with, there is no further direction and you accept it, no further direction is necessary.
But only because of the implementing application, madam.
my lord,
Would have been resolved over. The state
the
has completed
survey was-
The other issues may not be gone into at this stage.
my lord, yes, my lord. I have no issue. What is falling from your lordship is absolutely correct, my lord.
Yes, sir.
The only thing is, my lord, that survey which
Only
my
my
friend
lord,
is
my
saying.
prayer would be, my lord, lordship may direct the respondent
No, in writ appeal, my
acquire
lord, they can't ask for new direction, my
acquire the
lord.
land within time frame.
No, my lord, in the in writ appeal, what they are asking for a new direction, my lord, because what has happened, my lord, that survey also which was filed, there were certain issues on which we have filed our report, because survey report, I remember now, the survey report was filed, my lord, before this honorable court.
No, that
And
cannot be
we
the
have-
subject matter. That cannot be the subject
Yes,
matter. of the
that
appeal.
cannot be subject matter of writ appeal, my lord. So therefore
Yes.
now, as on today,
Whether they have correctly
they will
complied
proceed-
with or not, whether
Yes,
they have
ma'am.
correctly complied with or not, that
Yes,
is
ma'am.
that may be a subject matter of another proceeding.
My
Yes,
lord,
my
kindly
lord.
see my prayer portion only. Yes, sir.
In the appeal.
prayer
In
portion.
writ appeal, my lord,
Page
that in
number
writ appeal,
23.
this cannot be subject
22 and
matter, my
23
lord.
of the
Your
writ
lordship is
appeal.
absolutely right, my
Page
lord.
22
In
and
writ
23
appeal,
of
this
the
cannot
writ
be the subject matter.
Page 23,
22 and 23.
32,
For limited purpose only.
page 32,
22 and 23 of the memo of writ appeal.
32,
22. Yes.
22.
Page 22 of the writ appeal.
To set aside and
My
quash.
lord, number 2, my lord, to modify the impugned judgment order to the extent of directing the learned district session judge or collect the Shillong or Central Water Commission to conduct fresh inquiry survey to identify and find out whether the writ appellant's agricultural land measuring about such situated in such and
No,
such is
no.
affected.
When you prayed for this, by that time the survey has been completed.
They have completed the survey and they found that the land is under the water. My land is under the water.
So it is in your favor.
It is in my favor. And my lord, the last portion, my lord.
That is
it is
so, my
clear,
lord.
my lord. My lord,
That is so,
Pure
my lord.
last,
Your
page
lordship,
23.
Harakiri for you.
My lord, the last prayer, my lord, page 23. Lordship, may kindly bear with me to see. To give reasonable time frame to respond to conduct
Very
a
well,
fresh
take
survey or direct the responses and complete the land acquisition within reasonable time frame if
The,
such survey found to the land of the
the
writ
report
appellants.
filed by the poster, the Chola? During the pendency of the appeal,
Citizen notes to come up if the collector proceed for acquisition.
No,
So
we
my
have
only prayer, my lord.
we only said that if in the period of implementation, because we are not deciding on the issue whether the headman has acquired.
Yes, yes. Madam.
That's why you said that
Madam.
that issue which raised by the learned advocate general, we have kept it open.
I apologize.
And we have not adjudicated.
My
it.
lord, exactly. Madam. Only my concern, my lord, should keep some time. But otherwise, state will not proceed.
No, my lord, that issue,
Only concern, my lord,
there
to give a
are
time
issues,
frame.
my lord.
They have taken over the land, everything. It's a bit of issue notification.
In fact, we are also, if the
Time frame may be
compensation
given,
is
madam.
going to be too huge, my lord, we will scrap the entire project also, my lord. We will return the land also.
The state shall communicate a decision with regard to the payment of compensation to the writ petitioners within a fortnight. Because you see the first paragraph of the order itself, it records that you have to establish your right. If you have, suppose if you have given and it comes to the knowledge of the government, so that is why he said the government shall take a decision with regard to the implementation of the order and communicate the decision to you. That is the only thing I said.
Deeply noted.
Last sentence, what have you said?
May I please your Lordship? Lordship, in this matter, I am appearing on behalf of Mr. M. Chanda, Lordship, conducting counsel for the petitioner. Yes, unfortunately, Lordship, yesterday night his brother died, so he is in bereavement, your Lordship. On that ground, I am seeking an adjournment, Lordship.
You have filed your written notes.
Not yet, your lordship. Not yet, your lordship.
Yes, Mr. Musika, have you filed your written notes? No.
We have not filed. Well, we will file it on the next.
And you have filed your written notes.
No, Lordship.
Very well.
Till date, we have not
Prayer
filed.
for adjournment is made on behalf of the arguing counsel, as he is presently unable to attend the court due to bereavement in his.
My lord, state is in appeal in these matters, but we have not filed written notes, my lord. Kindly permit us to file written notes in these matters, my lord. And we will file
When?
within a week or 10 days maximum, my lord.
You have filed your written notes.
Not yet. Not yet.
Is it appearing for the first time before us?
No, it came earlier also, my lord. We have filed the
My lord,
paper
this
book
matter
in
is
this
coming
matter.
for the second time. My lord. On
Is
the
it
earlier
appearing for the
occasion,
second time?
my lord. On the earlier occasion, the state had sought for time.
Yes.
Where is our order? When did you pass her order? Find out.
List of appeal is well.
In this bench for the first time.
Yes, my lord.
They know. Prayer for adjournment is made on behalf of the state appellants. The matter stands adjourned for 2 weeks.
My lord, regarding regularization of work charge employees, my lord. The
My lord, it's
employees
not
are
regularization.
working.
My lord, the crux of the matter in these petition is the core issue to be decided was before the core issue before the learned single judge was whether government notification can override a statutory provision.
Because,
My
my
lord,
lord, we will show.
the pay revision rules 2018, my lord, extended the benefit of the fifth pay commission to work charge employees as well. Now that benefit was was taken away by a office memorandum.
Very good.
Obliged.